that could be solved and the construction should be recontinued as soon as possible. It would be my sincere efforts to come to a point of agreement that will make both the parties leave this table after this session happily. Now, I would like to add some few points that would be as everyone will agree that whatever discussions and agreements we make over here affect the clients the most. So all the decision making powers and alteration of the offers rest with my client, and I will be dealing in purely advisory capacity. And coming to the confidentiality of the discussion over here, it will be limited to the virtual premises we are in right now, and to assure that the non-disclosure agreement signed by both me and my client has been mailed to the learned counsel. Now, coming to the agenda for today's session, it would be to put forward the offers and solve the issue and the issue that is holding the construction as soon as possible. And lastly, I would say all the discussions would be made in bona fide intention from my side. Now I hand over to my client to put light on the issues from his perspective.
One and all, myself, Naveen, head of the project management department in luxury developers. This was my first task ever since I joined the company. That put it a lot of responsibility on my shoulders also. But first of all, I'll come to all that afterwards. I would like to say that I hope that you all are fine. And I am very thankful to Arjun and his council for agreeing to this negotiation process, because due to the urgent attention that this problem requires, negotiation is the best suited process, and other alternatives including court trials could have been much more time consuming and energy draining. And my counsel would be representing me throughout the session and is well acquainted with the facts of such an issue we are facing right now. So as I would cut to the chase and come to the facts of the issue and to the background of the issue, this was my first task ever since I joined the company, and it was a huge responsibility on me because because it was a task that involved a client which was who was a client from previous 15 years, and it was an agreement of a huge sum, but the bidding was given in favor of Easy Go by me, not only because Mr. Arjun was a good friend, but also because Easy Go partnered with fantastic designers, a well-known design house in Bangalore, and Relax Construction, who have experience in constructing villas, uh, which provided stability to their company. We had another option with low risk, but we decided to go with your client because we trusted you in your work, and we gave you the bid for 160 crores subject to terms and condition, and also provided for 10% of amount in advance. And all the works were going on time. All the works were going in time, but from the past 2 weeks, Mr. Arjun has not been answering my calls, neither has been answering my emails. And when I visited the construction site, the work has been halted, and I came to know that he has even ended his contract um,
Relax.
with Relax. And so the non-information on his part is very unreasonable, but we are willing to look past it because of the urgency this matter requires, and we are willing to see what we can do so that the construction work can be started as soon as possible, which will benefit both the parties here. Thank you.
Thank you so much. Good evening to everyone present here. I'm Labdhi Golecha, the counsel of Mr. Arjun, the owner of EasyGo. You can address me by my first name. We acknowledge the receipt and adhere to the non-disclosure agreement. At the very outset, I would like to thank Mr. Ronaldo, the owner of Fantastic Designers, for arranging this meeting, and Mr. Naveen, of course, for meeting with us. I hope everyone is keeping well and is safe. As you all might be aware that my client, Mr. Arjun, is engaged undertook the task to complete the construction of 16 luxury villas in the city of Mangalore. The time in this contract is the very essence of it, and due to unprecedented situations, my client has faced some delays in completing all his commitments. But there is still some time left, and through this negotiation, we wish to come at an agreement regarding the way of completing the remaining work. We assure you that we would be very flexible throughout and reach at an amicable solution to this problem, which although seems like a dead end now, but would prove to be a mere hurdle in the fantastic outcome which we would achieve. That being said, I would like to clarify that my role here in this whole process is limited to being an advisory counsel to Mr. Arjun, and the power to make the ultimate decision rests with him only. Making myself clear regarding these points, I would like to open the floor to my client, who is at a better position to explain the exact facts of the deal.
Good evening, everyone. It's a pleasure that we have got this opportunity to ease out our differences and settle all the relevant disputes which we have at hand. I'm very thankful to Mr. Ronaldo from the Fantastic Designers to convene this negotiation so that I can sort out all the disputes with Mr. Naveen, my very close friend with whom I entered into this agreement with the hope that I might get an experience in luxury house building, as well as she gets the opportunity to prove her mettle to her brother-in-law, to his brother-in-law in the near future. I would like to state that while we have been undergoing some difficulties, we are completely open to getting a negotiated settlement which is acceptable to both the parties. I'll do whatever I can in my personal capacity to ensure that Naveen, on my part, suffers from no shortcomings and he's able to get the work done on time and with complete efficiency. As has been specified before, the work, almost all the work has been done and only 20% of the work is remaining. I think so that's a very manageable figure and we will be able to complete the work well within time to ensure that no harm falls upon my dearest friend Naveen. That being said, my council has already specified the agenda and so has the council, the opposing council has also specified the agenda. I think we can now begin with the negotiation so as to arrive at a mutually acceptable settlement and solution. Thank you everyone for being here.
Thank you very much. Yeah,
And
thank
we
you so
assure
much.
you that we will also be open to the offers and suggestions put forward by you, because we too want to solve this as soon as possible so that we can carry on with the construction side, so that we can save both of ourselves from the damages and from the non-performance contract that we have pursued.
And yes, indeed, we are really thankful to Mr. Ronaldo, who is the main reason why we are sitting here for an amicable solution that will really benefit both the parties at the end of this session. So I would like to start with the meeting now. First of all, I really understand there would be some really grave issue why Mr. Arjun started to ignoring my client's phone calls and even discontinued giving the reports. I understand there must be a very great issue behind that, and we really consider that if you will share with us in this session. And moreover, I would love to put forward that we are really open to consider whatever the offers you are putting on the table, and we will even negotiate what we are putting on the table. So first of all, I would request council or even Arjun to please tell us the reasons and the offers that are from your side.
Thank you, council, opposing council, for listening to my concerns as well. Uh, while I feel very guilty of ignoring the calls made by Naveen, I would like to assure you that it was in complete good faith. And that is why we are at this negotiating table today, because I do not want any harm to befall upon my friend Naveen. The primary reason because of which the work stopped is COVID. All of us know how pandemic has affected us in multiple ways. And I would like to assure you that if given the opportunity, I would complete all my work well within time. However, due to COVID, the supply chain of important materials got affected, due to which there was delay in construction work. Also, I would like to tell you in full confidence that we are facing some issues due to which we could not complete the work in time. The issues are primarily financial since COVID has affected financial resources as well. However, I believe that if the opposing council and Naveen agree, we can arrive at a settlement which will enable us to complete the work as soon as possible. I would once again claim that I'm very sorry and very guilty that I ignored your calls, but that was not the aim of it. The aim is to achieve and do the work as soon as possible. My counsel will now put forth my exact condition in the legal terms, which I myself am not very conversant with.
Thank you so much, Mr. Arjun. So cutting to the chase, as told by my client, that we are indeed suffering from financial constraints. So therefore, if possible, Mr. Naveen, if possible, Mr. Naveen could arrange some financial resources by asking his brother-in-law, or there is one more option which we would like to put on the table. Relax Constructions, which is in constructing the whole which is constructing the whole villas, it has not it has stopped its working because of the reasons of outstanding payments, as my client gave the payments to the suppliers and the workers, and they both of them were constrained and they were not able to execute their work due to the pandemic. Therefore, the Relax Construction has not been given the payments, and due to that, the whole process has come to a halt. So therefore, if Mr. Naveen could arrange some negotiation with Relax for doing the work by giving some partial payment from their side, or by giving some assurance from their side, we can assure that once Relax Construction starts working, we will make it very sure that we complete the work before the 18th of December, or we could possibly do it by 10th of December as well, so that there is no penalty from your side. But in addition to that, we would request you, as you are well aware that we are having really financially, we are very constrained. Therefore, we request you to not lay any penalty on us post the stipulated period, because this is it was my client's fault not to tell you about the pandemics. Like, it was because of my client that 14 days after 14 days he did not inform, but the pandemic is the truth, and you all know that it is because of as there was a force majeure clause also in the agreement. Therefore, merely his not telling you should not make him liable for all the penalties. Therefore, I request the opposing party to adhere to be open to these suggestions and see the following for the coming course of action.
Thank you so much, Arjun and his counsel. If I may speak now, do you want to continue? Okay. He's on mute.
I would just like to clarify certain issues if it's not an issue. While I understand how important this project is for you because of your relationships with your brother-in-law, I would assure you that from our end, you will face no troubles in getting the project well within the time. Our key demand is that you just ask Relax Constructions to provide us with the basic construction material so that we can complete the project well within time. We assure you that we'll provide the Relax workers with all their due payments after the contract comes to an end and after we receive payment. Yeah, you may speak, and we would like to hear from your side as well.
Okay. Thank you so much. And your offer is very generous, but at least one thing is clear on the table, that we both want to end this dispute and continue the construction work as soon as possible. Coming to the second point, as you have said that because of the pandemic, the work has been halted, and we agree that the pandemic has been hard on all of us. But I would like to appreciate you on one thing, that beside the pandemic going, you have completed 80% of your work, and that too in good quality. And that is very appreciable on your part. And only 20% is left. And to my knowledge, only the finishing of construction site and other things are left. And we would like and we would consider your offer, because it is a genuine offer, and only 20% is left. And as you said that I have the responsibility to prove myself to my brother-in-law also, and it has been a major challenge for me since the day I have joined this company. And because of that, I have been very stressed since you stopped taking my calls. And I would suggest you one thing, because it seemed a little bit unfair on your part. If you would have informed us about this problem a little earlier, that you are having problems in funds and you are having financial crisis and crunches, we could have helped you earlier also. But simply stopping to take our calls is very unresponsible on your part and unprofessional, because we trusted you as a friend, and then we saw that you are bringing us stability also, and then we provided you with the contract. So it would be a little difficult to let go of what for the penalty, but we will see what we can do, and my counsel would put forth the counter offer, and we'll also look into yours.
Yeah, definitely. And first of all, thank you, Mr. Arjun and counsel, for putting your side on the table, and I really consider that. But you will also agree on one point, that my client is also answerable to someone. He's also accountable, and he has some authority on his shoulders too. So first of all, just as my client said, we at least come to a sense of cooperation that we both want to continue the work. And for that, we are even willing to give you some relaxation, but that would not be, I think that, in my opinion, it would not be of that much amount that you are expecting. But from our side, we can give you an offer of 2% contract money that would exactly, not exactly, but approximately amount to 3 crores. But you have to complete the work in the limited time, because my client is also answerable and is bounded by time. And one more thing about the Relax company, the main issue why they left, I guess, uh, not to blame, but your client, as you already accepted your mistake, you are related to that. Though we are willing to do everything from our end, but we consider if you first talk to them, and if see they are coming back, because in directly or indirectly they are benefiting your construction as well as my client's contract. So may I know if that 2% of appraisal on contract
I would
money and
also like to
yes.
add something that yes, that my counsel has already said that you should be the one contacting Relax company because they had issues with you, and I think your apology with them and payment of the outstanding debts with them can sort out the issue well. And as we are providing you 2% extra of the contract money, that is approximately 3 crores. I think that should solve the problem of providing the payment to Relax also. You can provide
Yes.
that payment to Relax and get them to work with you again. And I would say that if that this money of 2% we are offering to you extra, it would you like to repay it in the future? Because that is also of an utmost importance, because we already have had a contract of 160 crore and then you delayed it, and you have been unresponsible on your part. So we don't have any hurry, we can give you 2% extra, but on your point, are you willing to take the responsibility that you
And
will repay?
before that, I would like to add just a little point. Sorry, I'm interrupting like this.
No
There is
problem.
also some penalty on my client's shoulder for each day after the time bound. So if you consider that and then respond to whatever my client has said.
Absolutely. So I would like to clarify two things that while the payment made to be made to the Relax was due to our fault, it cannot be completely said a fault, but it was due to the pandemic. So I hope you understand that it was not completely fault. While I accept the guilt of not picking up the calls, the Relax issue was not completely under my control. However, I would like to say that the amount of 2 crores to 3 crore rupees will be a bit insufficient, and I would want that it could be raised a bit. Also, the issue of repayment that can be handled and it can be adjusted in the total contract amount of 160 crore rupees. And as far as negotiating with Relax is concerned, my primary motivation behind that was since luxury is such a famous company and it has a lot of clout in this industry. It can ask Relax to just delay their payments and delay their issues for a certain time, and then we can make the payment afterwards. This is just enough. The time period should be just enough for us to completely work well within the time. Also, we completely understand your position that you do not want to pay the penalty, and we'll adhere to that timeline. And I hope my counsel will be able to elaborate upon this a bit more.
Thank you so much. Yes, I would like to just point out that although your offer is generous enough that you're offering us 3.2 crores, but the issue with that is that at present we need 30 crores. And while we can do a bit of negotiation with that, like we can come down to 25 crores, but this is some amount which we are not asking you as a loan. This is some amount which we are asking you to give us in advance, which you were anyway going to give us at the end of the contract. While I understand that it might be a bit difficult for you to completely give the amount right now, and we also understand your concerns and your relation with your brother-in-law, but since you as a company, as my client has pointed out, that has very good reputation in the market, if they could, if not provide with 25 crores, they could give us half the payment of 12.5 crores, and remaining of that, like they can then negotiate with Relax company and ask them that we would provide you with the remaining amount. We would give them the 12.5 crores which you have provided to us, and the remaining amount we will provide it as soon as the contract is completed, and we have our all the money which we have. We will provide them with that, and that would not be an issue. The only problem is us going to relax companies that they uh, like, if you can also understand that my client is just a new person who has come into the industry, so it would be very difficult for the relaxed construction also to understand our concerns and our position. Therefore, you being a luxury being such a nice brand in the developing sector, they can convince, and I believe that they would be able to convince relaxed constructions, because we know that your constraints, what your constraints are, what time limitations you have, and without the consultation with relaxed constructions we would not be able to go ahead. Therefore, I hope you will understand our offer and give us 12.5 crores now, and negotiate with relax if it is possible, and if my
Um,
client agrees to it.
it is very nice of you to put forward a good figure so that now we can openly negotiate what both the parties are intending to give. But I know you have limitation, and that maybe this was not your fault, and it was all because of the pandemic that has been hard for all of us. But I would like for you to understand also that I am not the owner of the company. I am not the owner of luxury. I'm just a department head, and also I'm the brother-in-law of the owner of the company, to whom I have to prove myself to. So it brings a major responsibility in my on upon myself, and because I'm just a department head, I do not have the control to the accounts of the company. I do not have access to the assets and funds of the company. If if it would have been such case, I would have agreed to your offer, because it is more than genuine, because you are only asking for amount that has been given in the contract, but you just want an advance payment. We get your point, but because we have lack of funds, and I too don't have access to such amount of funds, my council would now propose a counter
Yes,
proposal to that, and then we can negotiate
definitely.
further.
I really appreciate what you have said, but I like to put forward a point, because before coming here, I thoroughly did my investigation from my side. I would like to put a point, though, Mr. Arjun and the council, I'm not putting the blame directly on you. Obviously, COVID was such an unforeseen situation that has also affected the returns of my client's company. But I would like to say there was a lack of intimation, that was force majeure. A prior intimation of 2 weeks would have, you know, you would have been helpful from my client side too. He's also answerable to his heads, and I guess ignoring the calls again, though you have apologized, I'm not blaming, but my client did his best to know if what is the reason behind that. But we are here for negotiation, and as I have discussed everything with my client before this session, we can raise the amount to 3% of the contract money. But we can do one thing. As I have already stated, returns of my client's company has always also been affected due to COVID. We can be a guarantor we can assure you by helping you in getting a loan from a bank by being a guarantor. My client would would put the guarantee, and it would help you getting the loan from the bank, because giving you 16 crores lump sum right now is really difficult. I hope you would understand, and I would really love to know what do you think about this offer.
Also, I would like
Absolutely.
to, if I may add, if I would like to add to my council's point, that we are not going into the penalty that you might face because of the 14 days prior notice you are not giving. We have not even stated that once. It is not that it hasn't crossed my mind, but because you have been a good friend and we are both on the table to negotiate, we are willing to let that go. So just so that, because you still have time and we want you to complete your contract in time, so we are willing to let that go, but you need to understand our situation also, that we are not in position to give you such a lump sum amount. And but as my counsel stated, that I can be a guarantor for you and you can get a loan from the bank. So that is a way how you can get a loan from the bank, and our both will be in a win-win situation, and that's how we propose
And
it.
you can also hire extra manpower by that and extra laborers to complete the work in the committed time.
I'm very thankful for the offer and especially the penalty clause. I understand your difficulties and the compromises which you are making. And the issue is that we do not know how much are you willing to guarantee. So if you could specify that
Okay.
and tell us in specifics, like how much are you willing to guarantee? Because this option on the face of it seems very feasible, and we indeed are going towards a negotiated settlement. So if we could know more particulars about the offer.
If
Yeah.
I am willing to,
Yes.
as I'm willing to give you 3% of the amount in advance. So if you keep 3% of that amount, then we can give you more we can guarantee you from the bank 2% of that amount. Like 2% was, my counsel would be in more better position to do the calculations.
Yes. Uh, I am just suggesting it. And Mr. Naveen, if you feel that this offer is not generous, you can also point out. We can also give some other offer to that. I am. I was thinking, like, my client is already providing you with 3%. That is approximately 5 crores. You can get 8 to 10 crores. That is again negotiable on both of our parts. 8 to 10 crores, that could also, the time factor will also play a major part in this, for how many years you will take to repay that. I guess if we agree on this, being a guarantor, we can also go with the negotiation session upon deciding what is the real amount and the time factor. So should I consider it you are agreeing upon this offer?
Yes, I think my client would also agree that the 8 to 10 crore amount of loan is very generous for your part, and we would like to repay that in. I think we would be able to repay that in the term of 5 to 10 years, which is a huge time gap. I understand that, but it would
Yeah.
depend on the bank which gives us the loan, like in what time it wants it. So therefore, we would. But one thing is still unclear, that about the negotiation with Relax company. So if we could get a hint that
Um,
what page you are on regarding that, I think we are done with most of the other things. So if we could
Yes.
just
Also, I have one more query, just one little conflict, that we are ready to be your guarantor in a bank. So that would require us also some guarantee, like a little, we would like to know all your assets and what liabilities you are in. We can also continue that in later in the session, but that is still under negotiation, because for us to be your guarantor for such a big amount, we would like to know what you hold and what you don't hold in your assets and in your liability. And coming to the point that we would be negotiating with Mr.
Arjun.
No, we are going to negotiate with
Relax.
Relax. Coming to the point that we are going to negotiate with
It
Relax.
is little confusing, I know.
Yes, because there is fantastic and there is relaxed. But see, the thing is, we gave you the contract only, not only because you were friend, but because you were giving us stability by contracting with fantastic and with relax. We don't have any direct contact with relax. You were the one who were the middlemen here, and you were the one who created a link between us and relax. And that was the main reason that you provided such instability, that we gave you the bidding. So, and we would look into this matter, that what we can do, if we can hire a middleman in that also, and let them contact him. But I think the major problem relax is facing is that the non-payment of dues. And once you pay that due and apologize to him directly and negotiate with him directly, I think that issue will be solved. I think my counsel would add on to that more.
Yes, to shortly adding upon what my client just said, we could arrange a meeting with Relax, but again, the major person that linked between my client's company and Relax is Mr. Arjun. So major part will be played by you. So
Your
I
presence would
request,
be very much
yes,
appreciable if such a meeting is
and
conducted.
I really request if you first talk to Relax on your part, and if and pay some amount that will make them work again, some little amount, and if they don't, then we can again come to some other solution to that, and we can be a party to the negotiation with them too.
Absolutely, I would definitely do that. I would just like to point out, as has been stated in the facts and as has been the facts before, I was suggested by Naveen to enter into an agreement with Relax and Fantastic and vouch for this contract and tender. So I feel that all three of us are on the same page in the sense that all three of us have interacted with each other before. And the bank guarantee can act as a trouble for you because it's an unnecessary financial difficulty on you. And if you could just ask Relax to delay their dues and delay their asking for dues to such an extent so that we can pay them back their whole amount. This would ensure that there is less responsibility on your part, and we are also directly in touch with Relax for the payment of their dues. And your money is not involved in that. In that sense, we would just want you as a mediatory capacity. However, in case that fails, we always have the option of taking the loan method where you can act as the guarantor and the work won't stop, in my opinion. We can discuss this in the next negotiation as soon as
Yes.
possible.
Just
And
adding
that would
one point to that, if my client agrees, I think what we can do as a feasible solution is that you can give us 4.8 crores as agreed by you, 3% of the amount right away. We will give that to Relax, and you can act as a mediator, and we will fix a negotiation, and then they can continue the work if they agree with that 4.8 crores and that amount. And after that, even if they do not agree, then we can go through the loan method as told by my client. And with that, I think we would be, there is everything sorted in sense that we would, Relax would start working. We would be done by the work till before 18th. Till I think we would be done, if my client agrees, you would be done by 10th itself. And then I think everything is sorted. So thank you so much.
Yes, and I really would like my client to add this if this offer is okay with you.
Okay. I would first like to clarify. You said that the work would be done by 10th of December or 10th of November.
10th of December. It's already 8th of November today.
Oh, sorry. No, 10th of November. So, okay. So you will be completing your work in 10 days.
10th of December, I said.
Okay. Very
I
sorry.
would like to point out one
Yes.
thing here. You are time bounded by 30th of November.
Yes.
And you
didn't
since the
realize-
start you're saying you will complete in time limited.
I would
Okay.
like to clarify that. Okay, we will discuss it in the next meeting, I guess.
Yes, I think
to responding to the offer made, I think that the feasible offer that you made is the combination of all the offers that were made on the table, and I think it is very feasible and plausible and acceptable on our part also. Coming to that the time bound will be 10th of November. We think that 10th of December. Sorry. So 10th of December, it would still be negotiated and talked on because there is some penalty on you also that you are aware of, that if you delay the work after 30th of November, you might have to face penalty. So we are not assuring you anything on that. We are not extending your deadline right now. But for the solutions that we have all combined and made a very feasible solution, and I really think that might work. I see that we are in a better position from what we were, and we are in talking terms now. And I hope that Mr. Arjun doesn't stop speaking, doesn't stop answering my calls now, and my counsel would like to continue now.
Yes, thank you indeed. And due to limited time, I guess we already came to a lot of cooperation and mutual decisions. And the points left, I guess, in couple of more or even one negotiation session would be enough to cover up that too. And my client's work would be completed on time limited, and the work should be started as soon as possible. So I would briefly like to conclude what we have discussed in this meeting. First of all, Mr. Arjun has agreed to complete the work in adherence of time. And second all, and there was a little confusion. I guess that confusion can be sorted out in the next meeting. And the work should continue. We both had a mutual understanding over that. And the offers that are already very clear, and I guess the loan of from bank and being a guarantor and fixing of the time limit, the money, we will be covering up in that in the next meeting. And I request the next meeting should be set in span of 1 or 2 days, because you all know we don't have that much time. And from ignoring each other and now coming and putting offers on the table. I guess we have already made a lot of progress, and I really hope in the next session my client and Mr. Arjun would be happy with whatever I have done.
We think we will be able to put an end to this dispute. I think like Mr. Arjun has finished 80% of his work. We have completed 80% of this negotiation process, and the left 20% and the complete paper agreement could be done in the next session.
Honorable judges, if I have the permission to continue with the closing statement, or should we directly move on?
No, please conclude it now. Yeah.
Thank you everyone for coming here. I would specifically like to thank Mr. Ronaldo for holding this negotiation, which could lead to such a fruitful session and fruitful conclusions. I would also like to thank Mr. Naveen for his exuberance and his willingness to negotiate so that we could arrive at a settlement and we could conclude with work as soon as possible. Some issue regarding the timeline has not been fixed and is yet to be discussed. That will be sorted out in the due course of negotiation. But thank you all for coming to the negotiation and arriving at a settlement which is acceptable to both of us. My client will now my counsel will now take over.
Thank you so much, everyone for present here and coming out in such an amicable solution. Just to summarize whatever we have discussed, as my client and the opposing counsel and client would agree that right now you would be giving us 3% of the contract amount, which is 4.8 crores right away, which we would give to Relax Constructions, and we will set a negotiation with them in which you would be acting as a mediator, and they would restart the construction process as soon as possible. And if they do not agree to it, we would be ready to take the loan from the bank with you acting as a guarantor, and that would be between 8 to 10 crores, which would depend regarding the demands of Relax Constructions. And that is it. And so the sum of the points regarding the penalty and the time frame would be discussed in the next negotiations. And we are very open to discussing whatever, as we have been, and you also have been. We really appreciate your efforts in coming together and reaching an amicable solution. That being said, again, thank you all and wish the best.
So much. I would just like to clarify that yes, we don't have any problem in being the guarantor 8 to 10 crore, but we have already said that it would be subject after looking at your financial statement, assets and liabilities. So let's put in hold to that for now, and then we can further continue in the next session after you present to us your report, financial report.
Apologies for that. Yeah.
Thank you. But thank you so much for accepting this negotiation process.
I would now like to request to the judges to move on to the question and answer session.
Yeah, I'll like to put first question to the advocate for Naveen. Since you were acting as an advocate, of course,
yes,
you must have seen that, I mean, under what conditions the present project is, and as very positive tenor of you and your client in trying to see that the project goes through and it is finished. So from that, in a way, positive attitude with which you discussed, that was commendable, and that is on both the sides, no doubt about it.
Thank you, sir.
When it comes to, suppose on that agreement is arrived at, because today you have discussed only two aspects. Number one is that how to resolve the dispute with Relax, which has walked out, and number two is to take care of the money, which should be given to Arjun so that he is able to complete the project. But then tell us, there are some fundamental things which were on which much would depend. Two things which come to my notice immediately is that it will, of course, as you said, that there are some penalties, etc., for delay which are there, and so therefore, sorry, on which we will be discussing in the next meeting. No problem about that. But then, have you kept in mind while negotiating these that how that would work out? Because tomorrow, all this goes on. then and on penalty, you say that we want to impose some penalty, which is not acceptable to Arjun. So today, all these negotiations would fall through. What has happened today?
Yes, sir.
And number two, that if this kind of settlement goes through, that 3% you are giving in advance now, which can be adjusted against the dues which are to be payable, and the loan you are getting it arranged, this is good. But it would result in some kind of modification in the contract. So what you would keep in mind as a lawyer on these two aspects?
Yes, sir. First of all, thank you very much for the question. I would like to say, first, resolving the main problem which is causing the dispute. I guess it was very significant to solve in this meeting first, and then coming to the other points. But due to constraint of time, we managed to continue with only the amount, how to arrange it, and how to procure the amount, and just continue the work which has been halting for very minute reasons, and everyone will be able to pay with their commitments on time. But coming to the penalties, we do had a offer for that too, but the Mr. Arjun in the starting said he will be adhering with the time limit. We were respecting that. He had, after 30th November, each day he will be penalized for 2 lakh rupees. I and my client discussed over it, and we said, as he's already going through a financial burden, and COVID is the major reason everyone is their savings are being saved, and we lessened the penalty, but penalty was still there, from 2 lakh to 1 lakh. And as we have already given 10% of advance payment to Mr. Arjun, I guess he had some type of liability to complete the work, and we were even ready to provide him with some extra money before the completion of the project. So I guess a 1 lakh penalty, which was completely 50% less than the original penalty, was justified.
Okay, to Naveen, the question is, Naveen, tell me, what were the considerations in your mind that you wanted to go ahead with the settlement in that sense? But because what were the pros and cons, or what was the position, merits and demerits in mediation? I don't know whether you know it or not. We call it Vatna and Batna.
Yes.
Patna is worst alternative to the negotiated settlement. That is what
Yes.
you are doing. And Batna is the best alternative to
Yes.
the negotiated settlement. So therefore, while working on this Vatna and Batna, what were the considerations in your mind that you want to go ahead with this? So that there should be a negotiated settlement rather than going to the court, or rather say terminating the contract and inviting problems and then going to court, etc. Maybe that in such a certain circumstances, had you gone to the court, maybe you could have got better, we don't know, or arbitration, you could have got a better deal and better out of it. In spite of that, why you wanted, what were the circumstances which led you to negotiate this deal?
Uh, Thank you so much, sir, for your question. And to the point that in court or in arbitration, we would have gotten a better amount. But our main aim to coming to this negotiation was we wanted to continue the construction site as soon as possible. And the reason behind that was it was a big responsibility that I upon myself, and it would have been upon me as my first task that I failed to do so. And if I would have failed to complete my first task, it would not have been bad on my company only, it would have been bad upon me, and I wouldn't have gotten a job anywhere else also. I would have not able to prove myself. That was the main aim. Second thing, that why we were negotiating and why did we not go for a higher amount, is that it is said that luxury developers contains 10% as a profit margin. But here we have already reserved more than 10% for our profit margin. We have more than 10% for the profit margin, because 160, because we are only giving them 160 crores and we are taking 198 crores from Mr. Fernandez. So in such a case, when we have profit more than the margin required in our company, we are in a position to provide them with extra money so that they can complete in time. In that way, we are also going to save the reputation of our company, that is by completing the construction in time. And also we can save the our profit margin also, because that's why only we were not willing to go above 5% of the construction rate. That is why we only offered for 4.8 crores. We did not want it to affect our profit margin. Neither did we want it to look bad on our company that we were not able to complete the construction site. This was our reason for coming to the negotiation table and not going for court. Also, court would have been very time consuming, and till the date we would have gotten a date and we would have settled this dispute, the wedding date that was of 25th December, it would have been passed on, and it would have looked very bad on me and my company, and I would have failed myself.
But what were the reasons? Look, we understand that now, in a way, the other side, or the Arjun, is out of money. He is facing financial crunch, and you are in that sense, what is called is, you are putting good money over bad money. As of today, you are taking that risk, because you are paying this 3%, which is 4.8 crores also. And for the bank loan, of course, which may be in his name, but then you are giving the guarantee. If he doesn't pay that, then as a guarantor, that liability can also come on you. So how you ensure in this entire deal that after getting this money, he completes the project? If he doesn't, what were the consideration in your mind in going ahead?
That's why we didn't agree on extended deadline, because if he fails to deliver his work after 30th November, we would absolutely go ahead with the penalty, because we are already giving him so much discount, and 5% was already our partner. We had this that we would go up to 5%, but we settled on 3%. That is a good point on us. And sorry sir, can you repeat your question once more?
No, what I'm saying is, if he's not able to complete this project,
Okay.
and you have pumped in this money,
Yes sir.
so your risk will
So,
increase from now
yes.
onward. So what were the considerations in your mind to go ahead with this?
Yes, sir. Okay, I get your point now. First thing in my mind was, because I was under so much pressure to complete my responsibility, and second thing, when I said about the guarantor thing, that's why I clarified that first I would like to see your assets and liability, that because in some case you are in default and you would not be able to pay the liability. I don't want to be the one paying. That's why I said that to put on hold. Show me your statement that are you in position to take such amount of loan, that even only after that only we will continue with that. And the penalty is still there, because the penalty, if he fails to do so, we are not reducing the penalty in any way. If he still fails to give us the construction site built after 30th November, we can apply penalty on him for rupees per 2 lakh per day. And we can extend it up to 10%, 10% of the contract amount. So that penalty is still there, and we are
Okay,
not.
here's quick question to your lawyer, which you can take 1 minute
Yes,
in
sir.
answering. What are the precautions you will take in drafting the agreement of this type, that tomorrow if he fails, Arjun fails in spite of all this, how you protect your interest? You are paying this
Yes,
amount.
sir.
Suppose negotiations go through and it ultimately results in settlement. But then in order to ensure that this other side, or Arjun, completes his project and fulfills his obligation, and if he fails,
Yes, sir.
what kind of precautions you will take in an agreement like this?
Yes, sir. So we already have discussion over it, and I'm not blaming Arjun, but he had already once defied my client, and it was really difficult to trust him again. We had an offer that my client would hire an expert, or he would himself regularly visit to the surprisingly a surprise visit to the site and see if progress is being made after the settlement is done on part of Arjun, to ensure that he is not again uh, backing from his words. Expert would be hired, and the expenses, the 10% of the expenses of hiring the expert would be borne by Arjun, because again it was on his part, though we are helping him financially, but we are also in a crisis of COVID, and my client is also suffering from loss of returns. And even if nothing helps, even if my client's reputation is dented and the contract is lost, the main facility we are left with is going to the court and challenging Arjun's absence.
That would be like this time we went for negotiation table because we both wanted to complete this contract and construction site. But if he again defaults and does this thing, or if the penalty, and if he is liable to penalty again, then we will insert a clause that this time we would like to, if such a thing happens, you will have to pay another penalty, and we can also go to court for it without any warning or previous indications.
Okay, I will like to ask my co-judges. Would you like to put questions to the other side now, or should I put? But I think you should also put some questions, Mr. Ratan Singh or Pinky.
Yes, I just like, before we go to the other side, I just have a question for the council, for the NT team. I needed to know, you had specifically asked a question. I just want to take that forward. The amount that is being proposed to be advanced as part of the settlement, when you think of drafting that clause, you don't think of recovery of that amount altogether,
Yes.
or a higher penalty. Wouldn't that have been one of the options that would have been desired in the circumstance?
Yes, ma'am. Ma'am, as I due to constraint of time, we were not able to do all the dealings in this session. When in the next negotiation session, when we have discussed about the bank amount that we are taking as a loan and the time period it has to be repaid, and my client would have analyzed the assets and liabilities, we would have also demanded some guarantee or a piece of land, something, or a rate of interest at least, in which after all, I am representing a businessman, and businessman deals in profits, and we definitely would have looked into it, and rate of interest or a piece of land as a guarantee would have helped in it.
Or shares in their company,
Yes, something like this.
such type of things we would have asked for in the contract for additional guarantee.
Very well. For Naveen, the other side, for Arjun, if I may, let me ask the counsel for Arjun. Of course, the client is also perfectly open to answer the question. Do you think in these circumstances, the present case, you could have invoked the force majeure and done more profitably on that account rather than the settlement?
Ma'am, I personally feel that the force majeure clause would not have been of much help, because at the end of everything, we needed money. And in this case, the money would have only been supplied either by the luxury or by relax, and force majeure clause would not have helped us per se. Also, regarding the penalty clause, what I would have done personally was that I would have hired extra laborers to complete the work on time. Because in this case, the intention, and as is evident from the facts, the intention of Arjun is to not run away, but to stay in this line for a long period of time and thus develop luxury homes. So my primary aim would have been just to pay back the loan as soon as possible and to get the work done on time so that I do not lose on my future business. I would have also agreed to a lot of things which they demanded, because it might seem unreasonable in the short period of time, but in the longer period of time, I wanted to stay in this industry. It was my dream of being involved in constructing luxury homes. So I would have foregone my profit and my peace of mind to take a loan just so that I can exist in this industry. And in that way, I do not think that today's settlement was that bad an option, considering that I got the money which I wanted. I also got an assurance that the issue of relax might be negotiated by the opposing party. So in that way, I do not think that I got the bad part of the deal. In fact, I got the best part of the deal because I wanted money and I got that. I've been struggling very financially in a very difficult way, and I'm nearing bankruptcy. So I would have saved my face and I would have remained in this industry if I took the amount.
Counsel for Arjun, would you like to add?
Yes, ma'am. Sorry, if you are asking me or
No.
NT30.
No, counsel of Mr. Arjun.
Okay. Sorry.
Thank you so much. Just to add to what my client said, although there was a force majeure clause, but there was a rider with that you have to inform about that within 14 days, which my client defied. And there have been many lags from his part. So just to say that this was also just a mistake, and to say that I again want an apology. Am I audible?
Yes,
Yes, yes, you are audible.
And just to ask for an apology and then claim on that would have been not it would have acted it might have acted against us rather than acting in favor of us. Therefore we went for the safe way round to ask for settlement, which we got. And the rest of the issues which we will discuss, there was some problem regarding the timelines, but we would discuss later on. But going to force majeure clause was not a better option according to my limited knowledge, respected judges.
Tell one thing more here. When you, before coming to this negotiating table today, what kind of homework did you do, in the sense that what are the strong points of your case, what are the strong points of the case of the other side, and likewise weak points, etc., so that in negotiation you could just project your strong points and then play around on their weak points and tell them, so that they come. So what, according to you, are the weak points of the other side? You have told about your case. What, according to you, are the good points and weak points of the other side, legally?
Thank you so much, respected sir.
Since you
Legally,
are
the point.
counsel, we are asking you a legal question, not factual.
Okay, sir. So I think I might go into factual a bit, because here the time.
Oh, of course. Yeah.
Time was the essence of the contract, and here if they the weakest point was time only. They did not have time. We did not. We were not constrained in that sense, but the other party was constrained very much due to time, and they had the financial capabilities which we did not have. Therefore we knew their strong point was their financial capabilities, and the weak point was time, as well as their relation with the other party, with his brother-in-law. Therefore these were the points which I took into account for before coming to the table.
Honorable judges, if I may add,
Yeah, please.
during the course of this negotiation, one important fact that which we knew was that opposing party was in a relationship with Alexander, and that relationship was of prime importance to the opposing party. And if we had defaulted on our part, the penalty was not that high. But if they had defaulted, the penalty was extreme. So we knew that they wanted to get the work done well within the time. Otherwise, they would have faced this issue. Another factor is that Naveen personally wanted to prove his mettle, and he would not have been interested in showing a bad face to his brother-in-law. And hence, we knew that they would be amenable to make changes to the original contract and give us some leeway. Also, one of the strongest points they had was they were already established, and they were in a relationship with Relax and Fantastic. And because of their brand value, we got the tender in the first place. So we believe that they would have financial capacity which could help move us out of this financial struggle. And we use that as a leverage and ask them for money, which they did give us, and that helped us go out of this conundrum. Because for us, the penalty would not have been that high, but for them, the penalty would have been very extreme. And it was not just the penalty, but the relationships with Alexander and the future business he would have contributed to, which they would have lost. In our case, we would have also faced a lot of difficulties, but the trade-off was not that high.
But as you said that it was a question of your career. So maybe they might have got a worse hit as far as this transaction is concerned, but then it would have finished your career. So was that the consideration in the mind of Naveen's counsel, that we should take advantage of that?
Respected. I'm so sorry. You can answer.
Yeah.
No,
I'm asking Naveen's counsel now.
Yes, sir. So actually,
The
my
same question
intention
to you. What were your consideration in
Sir,
your mind?
honestly, my intention was bona fide, but by listening this view of yours, I guess would have been in favor of that. But I would like to add, we were constrained to put 5% of the profit, but we agreed at 3%, which I guess 160 crores, 2% we have saved for Mr. Naveen. And already his company is benefiting 10% from overall contract. I guess we also had done a good deal in that. And yes, counsel, you may proceed with your answer.
The question was directed to you only, therefore I don't think
Sir
I
said.
would add that we already had the profit margin we needed to flourish in for this for luxury developers. We already had the profit margin in our hand, so we had the option to give them till 5% of the contract amount, but we agreed on 3% also, and they too got their point. So I think that was a win-win for both the side. But because we already had saved our profit margin 10%, and we were profiting a lot more because we gave you the bid in 160 crores. So that was a plus point. And then too, when we had the limit to go up till 5%, we agreed only on 3%. So that's how we think we both had our win-wins. But this was a BATNA for us, that in 3% only we were willing to give you also, and we are going to complete our construction in time also, and we are going to save our profit margin also.
Okay, thank you.
To the Naveens, can I just ask one question?
Yes, sir.
Naveen's
Yes, sir.
could you not think of releasing the funds which you are contemplating directly to the subcontractors and vendors? Ultimately, that is what they were looking at. In construction industry, this is how work happens, right? They were financially constrained. You could have very well agreed to directly release this payment to the subcontractors and vendors. How do you look at this? As an option.
Sir, I'm really sorry. Your voice was very less. Still, I
Yes.
got some of the question, but I would, for answering better, I would ask you, please pardon again.
He asked you why, since they were facing financial crunch, why didn't you go wholeheartedly in helping them yourself? I think,
Yes.
Mr. Ratan Singh, you're saying instead of arranging loan for them, they should have given it from their pocket. That is what the question was?
What I said, whatever money they are releasing, they should release, they could have thought of releasing directly to the vendors and the subcontractors.
Okay. Instead, that
Okay.
is to those
Relax. company.
relax.
Yes, sir.
To ensure that money goes to right people. Yeah.
Yes, sir. Thank you so much for this question. First of all, as answering on the behalf of my client, he wanted to maintain relationships for a long term with his friend. As in business, everyone will agree on this. In business, contacts is the main thing that everyone needs to flourish. And talking about relax, I was not the main party contacting him, though. As now I can talk about my confidential information. It was given in it that Mr. Arjun came up with the idea that I will provide you in time with quality if I tie up with relax and fantastic. So I guess it relax was a little bit stubborn on getting financial help. I guess it would have been better to help Arjun. That will save that relationship and contact for me, and my client can go in further dealings with relax too, as we have cohabited in a contract.
I would like to add something. As our last deal that happened, it was said that they would give the 4.8 crore. They would first offer the 4.8 crores to Relax only, and then if Relax doesn't approve to it, then they will go to bank for loan. So that was the last thing that we negotiated on. So if things goes like it, that we are giving them 4.8 crores that they are offering to Relax, and we are planning to and things go smoothly, then in a way we help them who and indirectly help Relax also. In a way we provided
Maintain
relationships with both. We showed them that we are helping them also. We are providing you with 4.8 crores, but by helping them, we also offered them that you can give this money to Relax also, or the last offer was. So in this way, we maintain a relationship with both, and the problem at hand, that they are also having financial crunches, they cannot ask for further help also, because we have already provided them with 4.8 crores, and Relax will also won't be able to ask, because won't be able to raise a conflict in future also, because that 4.8 crores will be going to Relax only. So if the last offer that way goes smoothly, things can go like this.
Yeah, you can only one suggestion. When it goes smoothly in the contract, when you entered, ensure that some clause that money is given to them only and not utilized for any other purpose.
Yes, sir.
Yes. Okay. Thank you, everybody.
Thank
Any
you
other
so
question?
much.
I think we can go ahead. Yeah.
Yes, absolutely. we
Thank
can.
you so much, sir.
Thank you.
Also know how to use the score sheet here. Huh?
Yeah.
Every time we do something, we learn something more. Justice Secretary.
We are upskilling ourselves.
But this is the advantage of participation.
Exactly.
Very strong on this, that the more you participate, the more you learn, whichever way it goes.
Yes.
I was noticing you are using the larger iPad.
Yeah, I have 1, 2, 3 iPads, and I am on computer screen. You advocates and senior advocates and additional solicitor general, you may be having more than one cases at one point of time, I have heard. So you are appearing in Bombay High Court also, Supreme Court also, Delhi High Court also at the same time. But occasionally I also have more than one cases at a time.
Not
But
only
then,
this,
then only advantage is.
No, I'll interrupt you. I have seen you jumping from one to the other. So please, I don't want this comment on a one-way traffic. It applies equally to judges and more to Justice Secretary.
Yeah. I take it as a compliment.
Of course, nothing less. It's always a delight, and I've seen you actually filling in at the same time, and we are also, by now you're right, going between courts and cases and other activities at times.
Yeah.
But as I said, you hone your skills constantly.
Yeah.
Manage.
Learning, unlearning, upskilling, new skills. So many things.
Second generation, all said and done.
Yeah.
So, good evening to one and all present here. I, Aniket Datta, on behalf of Team Nya Shastram, invite you all to the valedictory ceremony of the first Ratan Casing National Negotiation Competition 2020. Without further ado, I ask Ms. Saundarya Rathore to introduce Honorable Justice Dr. A.K. Sikri Sir, former Judge Supreme Court of India. Over to you, Saundarya.
Thank you, Aniket. I welcome all the judges and take immense pleasure in introducing Honorable Justice Dr. A.K. Sikri. Honorable Justice Dr. A.K. Sikri is a former judge of the Supreme Court of India and an eminent jurist. He also served as a judge and acting Chief Justice of the Delhi High Court and the Chief Justice of the Punjab and Haryana High Court before being elevated to the Supreme Court in 2013. He retired as the senior most judge of the Supreme Court in 2019 with more than 4,500 verdicts in his name. Presently, he is an international judge at the Singapore International Commercial Court. He was conferred Doctorate of Law by Ram Manohar Lohia National Law University, Lucknow in 2013 and was also chosen as one of the 50 most influential persons in intellectual property in the world by Managing Intellectual Property Association in 2007. Currently, he is also serving as the chairperson of the News Broadcasting Standards Association and the Ombudsman and Ethics Officer of the Federation of Indian Fantasy Sports. We welcome you, sir.
Thank you. You want me to speak?
Sir, in a bit, sir.
Yeah, okay.
Yeah.
So
Thank
thank you, everybody. And first of all, I'll say that I congratulate the organizers for organizing this competition. And I really marvel at this idea because of the reason that up to now, traditionally, we have been hearing about moot court competitions. So moot court competition is one competition where it's a problem which relates to court, and people are arguing in front of court and in front of judges. And so therefore honing your argumentative skills, when you give your memorials, your research skills, etc., which are there, but that all happens in court. What is a trend which is developing now, and because of that I gave these remarks, are that ADR, alternate dispute resolution system, is also becoming a very, very important tool of resolving the disputes. And when we talk of ADR, alternative dispute resolution, it generally we talk of conciliation, lok adalats, mediation, etc. But if you see, negotiation is one thing with which everything starts, and it should. Actually, the negotiation is not given that kind of importance in our legal system, which leads to what we call dispute avoidance. Because if the negotiation is successful, there would not be any dispute at all. And so therefore, that was a reason I was really admiring when I saw that this on negotiation also, and the students or the young lawyers should know how to conduct the negotiations, or even the parties, and what are the stakes, etc. The difference between negotiation and mediation would be that in mediation, there's one person who is mediator in between as well, who may help the two persons to negotiate. They are in a way negotiating, but yes, the role of mediator becomes very, very important in the whole process. But negotiation is even a precursor to the mediation. And if you know, in the Industrial Dispute Act, 1947, that is what was recognized. And it's really, I would admire in that sense the wisdom of the lawmakers at that time, that they discussed about the negotiations, they discussed about conciliation, but today conciliation and mediation, whether they are two different terms or they are two into one, there's a lot of debate on that. It is not necessary to go into that. And Industrial Dispute Act talked of this adjudication through the process of the court in labor court only if conciliation also fails, which is made a mandatory provision. And so in this context, I was saying that negotiation becomes a very, very important. And in the whole process, what is to be seen and what should be, as you could gauge from the questions also, that in mediation, or the same principle would apply in negotiation as well, that it is not that the two parties have to take their respective positions, which is the position in adjudication, that they take their position, they stick to their position, they say that we are right. Here, you, instead of taking your position, you look into your interest and interest of the other party also. Yes, while negotiating, you have to understand what are the shortcomings of your case and what are the strong points of your case, so that you are able to play around that. But at the same time, you discuss and you keep in mind the plus and the minus points and pros and cons of the other side as well. And as I always say, this is a situation, why it becomes, or it has the potential of becoming a win-win situation, is that, as I said, in adjudication, we take positions. So there the situation is I versus you. I think about myself, my case only, and from my prism. And sometimes while taking that position, I don't even see what are the shortcomings in my case. As we say, that even if I am seeing myself, I see from the outside, not from within. If I see myself from within, then I may understand that, look, some of the problems or conflict may have arisen because of my fault also. And the other side is not, to be blamed to that extent. But we don't do that. And likewise, the other side. Therefore, I call it I versus you position. But when we sit on negotiating table and the purpose is to resolve, there are 2 or 3 advantages which come. It from I versus you, it becomes we, because both of us are sitting together and we are looking at the each side as well. So that synthesis, that harmony which is created by that atmosphere, And the second aspect is that we look into, there can be so many solutions to that problem. But in adjudication, it is only one side wins, one side loses, or partially wins, partially loses. And the court has to only decide on those dotted lines. And but the avenues which are there in negotiation or mediation, there are so many, and you can come out with some radical kinds of solutions which are not possible in the court system, whether it is, or any adjudicatory system, whether it is court system or it is arbitration, which are adjudicatory in nature. And that is why it is called for win-win situation. And in COVID times, because we were asked to talk about COVID and the arbitration and mediation in the COVID times, but it has becoming, because of COVID times, it has become more important. Not only in last 6 or 7 months, courts have not been able to, naturally the functioning is not normal. Even it is happening on virtual platform where to video conferencing, the hearings are taking place. But everybody knows that it is only important matters, and even if normal matters, they have started off late now. But the clearance of the cases is not that much, which is there in the normal times. So in new normals, we know the court functioning is not that efficient. So we have to think of the methods, which and another offshoot of this COVID is going to be that many issues like the present case which we're discussing, whether this the clause of what you call that section 56 which we were discussing, whether that arises, pardon?
Force majeure, I think.
Force majeure arises or not. Now, such kinds of questions, and when the frustrations of the contracts, etc., there's, and if the cases are not settled at this stage, courts are tomorrow going to be burdened with so many cases. So therefore, the today discussion is going on dispute avoidance, which is very, very important. And the parties have realized, because the business has been hit for so many reasons, all parties, like in this case also the Naveen side was saying that, look, we have also faced financial crunch because of these reasons. So nobody would like to go to court and waste time and take long years in that. So arbitration and mediation becomes very, very important. I'll include negotiation in that. But then even before arbitration, it has to be negotiation or mediation. If only it fails, then one may go for arbitration. And so that another thing which I would say is here, and it is giving rise to a new normal or adapting to, is what is called ODR, online dispute resolution. The technology which was up to now facilitators, it is now seen that it can transform the entire judicial system, entire legal system. It's not time to say in detail on that, but only to tell you that the government is working on that. Niti Aayog has constituted a committee, and it has already come out with a draft report, which was put on their website, I think 2 or 3 days ago. And the attempt is to come out, and the ODR is online dispute resolution, not only through court medium, even outsourcing. It's going to be very interesting thing. Some of the types of cases which can be outsourced and can be given to private hands to decide those cases. It's happening in few countries. It is really very, very if I say that a liberal attitude, that till date it is seen as a sovereign function only, which the courts would do or the state would do. But then that can be to some extent outsourced. It has been tried, as I said, because I know so much of it. The advisory committee, which is constituted by Niti Aayog, and we have come out with a report. I am incidentally the chairman of that committee, and we plan to release this report by 26th November on Law Day or Constitutional Day. And that is why now we are going to discuss to stakeholders. I'll request persons like Pinky Anand and Ratan Singh also to just see that, and whatever suggestions you can give, we will welcome those suggestions. So my only message to the young generation is that take it as a challenge, accept it, and it is opening lots of opportunities for you in various directions. So don't think that COVID has brought about the situation which will ruin your career, or which may be a stumbling block. It will afford many, many opportunities for you. It is for you to accept that challenge. Thank you.
Thank you so much, sir, for an enlightening session. I now ask Ms. Manvi Kumar Saida to introduce Dr. Pinky Anand ma'am, Senior Advocate, Supreme Court of India, and former Additional Solicitor General of India. Over to you, Manvi.
Thank you, Aniket. Good evening, everyone. Though ma'am needs no introduction, it is a matter of great privilege that I have the opportunity to introduce Dr. Pinky Anand. Ma'am is a former Additional Advocate General for the state of Uttarakhand, following which in 2014, ma'am was appointed as an Additional Solicitor General of India. Ma'am is currently a senior advocate practicing in the Supreme Court of India and is considered an expert in the field of constitutional law, family law, environmental law, and corporate law, among others. Ma'am has received numerous accolades during her career, including the French National Order of Merit and the Bharat Nirman Award for Excellence. A versatile and multifaceted person, ma'am's accomplishments extend from legal expertise, media, politics, as well as social activities. It is indeed a great honor to have you among us today, ma'am. And on that note, I extend a very warm welcome to you.
Thank you so much, Manvi. Very generous of you. And I really appreciate the fact that I have come after Justice Sikri, because I only have to add a couple of things, if at all, because he's taken a wide canvas of discussion and being at the helm of affairs in a number of directions, including the Singapore arbitration and the committee that he was recently talking about. In fact, that was one of the things that I thought one would address. But before I even go there, on the counseling and the mediation session, or rather the negotiation session that we just had, what I found the most enterprising amongst this was from Naveen's side, the NT12 team, because the offer made was based on the fact that they had profits in hand, part of which they could disburse and yet retain a profit in their hands. I thought that was the most honorable negotiating point that came across, because if you could really function in that domain, then obviously most disputes would get resolved. The problem with negotiation and mediation is everybody wants to give the least, not the most. So there, I think we need to edge towards the goal of resolving disputes in a direction which would ultimately be an achievement for all, as Justice Sikri said, win-win for all. I do believe that any of these mechanisms which are part of the negotiation or mediation actually are give a better result. Adjudication has its own pitfalls, aside from the factum of time, cost constraint, efficiency, dealing on the dotted line. In addition, mediation also gives you the option of preparing a fresh contract to the extent that you cover yourself for the exigencies that you have negotiated with. You can go beyond the existing contract. So it gives you that leverage. COVID-19, Justice Sikri also mentioned, I'll just add on a statement here to say, I think COVID-19 has taught us a lot. And definitely to deal with the existing situation with virtual technology and other mechanisms that are available to us, and also to learn at the same time, which we mentioned during the course of this session, including second generation people who are there on this session, including myself. Having said that, I think we have been now coming up with more mechanisms in contracts also. For example, most contracts today, you will find on the infrastructure front or others, have a contract and a provision for conciliation or negotiation, and only in the event of failure to go into arbitration. In fact, I have done cases myself where, because of lack of going for conciliation, the proceedings were held to be static, and they had to resort to mediation before they could come to the adjudication forum. And I think that is a very welcome development, as I said in the first instance. The online dispute resolution is definitely a marvelous mechanism. It's like having a lok adalat or resolution of disputes without any intervention of third person, so to say, in the front, and based upon the documents, etc. The government is also successfully looking at it. The Ministry of the Department of Consumer Affairs also has come out with some proposal for COVID-19 related issues. In fact, I think from time to time, we'll see that during COVID-19, at least on 4 fronts, government has issued circular relating to force majeure. That's why, in fact, force majeure has become one of the most biggest imperatives that we need to look into in the course of current day discussions, because it is a genuine problem. The question of how to deal with it in law and to deal with it in mediation and or conciliation is something that we really need to look at closely for all of us youngsters who are developing ourselves during this domain time of COVID-19. So with this, I think I covered some of the territory that I could only add on. And it indeed has been a pleasure. A first time ever mediation session that I have been to. I welcome all the participants, and I think they did a marvelous job. We can always see the spirit, and the spirit was definitely one of conciliation, which is what we need to learn first before we learn the mechanisms of conciliation or the legal mechanisms of conciliation. So with that, I thank everybody who's been here. Thank you very much.
Thank you very much, ma'am, for your kind words. I now ask Mr. R.F. Srejant Prasad to introduce Mr. Ratan K. Singh, Advocate and Arbitrator, Supreme Court of India. Over to you, R.F.
Thank you, Aniket. Good evening to one and all present here and to our viewers watching us through the live stream. I am Arav, and I've received this golden opportunity. Practice includes arbitration, construction, infrastructure, engineering and technology law, real estate, commercial law.
There, we can hear you.
Yeah, am I audible? I'm really sorry. Yes. It showed network issue.
You're audible now.
I'm really sorry for the interruption. Continuing, Mr. Ratan K. Singh heads Chambers of Ratan K. Singh. His area of practice includes arbitration, construction, infrastructure, engineering and technology law, real estate, commercial law, mining law, etc. He did his master's in geology and bachelor's in law from Delhi University in the year 1996. He's fellow of Chartered Institute of Law from Delhi University in 1996. And he's fellow of Chartered Institute of Arbitrators, FCI ARB UK, and has done diploma in international commercial arbitration from CIARB. He's the founder chairman of Society of Construction Law India. He's also Director of India, branch of Chartered Institute of Arbitrators, CIARB UK. He sits as arbitrator and has chaired or practiced as multiple tribunal members or counsel in many domestic and international arbitrations, ad hoc, as well as under the rules of International Chambers of Commerce, Paris, Singapore International Arbitration Center, Indian Council of Arbitration, Delhi, International Arbitration Center, etc. He's on the panel of arbitrators of Kuala Lumpur Regional Center.
I think that is enough. That is enough. Let us. Yeah.
So, like, these are very few lines for you. Please let me continue, sir. Only few lines left, sir.
Thank you very much. We have to save everybody's time.
Okay, so it was an honor introducing sir and having you here. I'm really sorry for the interruption that happened due to the network issues.
Thank you. Thank you for introduction. I must thank the organizers to start with for organizing this event on negotiation, which is a bit neglected area in India, though mediation has picked up very well. But structured mediation and awareness about structured mediation and training for this is not common. It is rare. So this is a good initiative, and I hope and wish that this initiative goes a long way. That is one thing I would like to say. Second thing is, so far as this, all of this, see, negotiation, as Mr. Justice Sikri was also talking about, negotiation is not only about dispute resolution. It helps in dispute avoidance. In fact, whenever we talk about and teach construction arbitration, then we give a lot of emphasis on negotiation during the course of execution of the work itself. It really helps the project as a whole. So it is very important that this initiative has been undertaken, and I must thank Abhishek and his whole team for this. Virtual hearing and all hearings in virtual mode and all these initiatives in virtual mode, I can only say that something which had to happen after 20 years is happening now. Ultimately, things were going in that direction where people would be doing things virtually. We are doing it now, and this pandemic has taught us how to go about it. And it is, speaking for myself, and Mr. Justice Sikri will agree, and Mrs. Pinky Anand will also agree, that it has been so, by and large, satisfying. This whole experience has been satisfying. It saves everybody's time to start with. and it saves resources. It makes the whole process cost effective, time effective. That is another important aspect. Speaking for myself, during this COVID, I have done many international arbitrations, domestic arbitrations. In fact, I did two arbitration, one in emergency arbitration in Tokyo and one main arbitration in Tokyo. All of this went very well without any difficulty at all. In fact, in one arbitration, it is a big power plant arbitration, construction arbitration, where we have foreign experts on delay and disruption. I have been cross-examining. I have already cross-examined on 9 days during this 1 month. And it is going very, very smooth. It's not troubling at all. So this fear that cross-examinations cannot be undertaken, I think one should rethink about this. Cross-examination is also possible. Hearings are possible. This fear that if your proceeding is document heavy, which generally construction arbitrations are or other bigger arbitrations are, even if you have bulky documents, heavy documents, you can still manage it very efficiently with certain housekeeping issues in mind. So I would say that it is interesting development which has happened, that is virtual hearings and all. So far as I would love to see law schools doing two things. One, teaching negotiation. Negotiation is something which happens every day in every project, everywhere. But question is, structured negotiation is not something you can do it just because you have neck for negotiation or you speak well. It is something you have to learn. More you learn, more you get out of this whole process. Another aspect is because this today's topic also talks about arbitration as well. I'll only add one thing, that teaching or knowing statutory provisions of Arbitration and Conciliation Act is not enough. We have to create awareness amongst all stakeholders about international best practices, global best practices of practice and procedures. Practice and procedures are something which really need to be given emphasis on. In fact, I have written one for a book on construction arbitration. I have tried to give emphasis on only practice and procedure. I have not gone into any provision of Arbitration and Conciliation Act. This book should come out in January. There are other authors as well. So practice and procedure, these two aspects should be given emphasis in law schools and by all arbitration institutions everywhere. And last, that awareness amongst all stakeholders, including the lawyers and arbitrators, about importance of domain knowledge. If you are like today's construction, the topic was on construction arbitration. Now construction arbitration has its own peculiarities. So domain knowledge about this industry is really helpful. In fact, if we see the topic, the facts which were given to the parties, I remember having advised once for the refinery in Bhatinda, which was a 40,000 crore project. And in identical situation, the main contractor at the verge of commissioning of the project had gone almost bankrupt. And so employers were taking opinions, and one very big law firm gave them opinion that encash the bank guarantee. And then they came to take my advice. I said, tell me, what is the value of your project? It is 40,000 crore. And how much you get out of this bank guarantee? So rather, you should help the main contractor with resources, give some loan, take some extra interest, rather help them so that you help yourself in saving the project. So this helps us if we have domain and industry knowledge. So with this, I would again thank Abhishek and his team, and I must thank My Lord Justice Sikri and Pinky Anand for taking out time for this event and being part of this. Thank you very much.
Thank you very much, sir. I now ask Ms. Mishi Agarwal to introduce Mr. Animesh Kumar Singh, partner Fiducia Legal.
Thank you, Aniket. Animesh Kumar sir is the partner at Fiducia Legal Associates and Solicitors, Delhi, and practices in the Supreme Court of India. Mr. Animesh Kumar has a diverse experience in general civil and criminal litigation before various high courts and Supreme Court of India. In a short span of time, he has had numerous reported judgments in his name. One such work was regarding arbitration on fraud, which was highly appreciated and also included in course study for some of the premier law schools of India, like the NLSIU and the Jindal Global Law School, Haryana. He possesses vast experience in the field of law related to educational institutions and appears against educational regulators like AICTE, MCI, NCTEE before Honorable Delhi High Court and the Supreme Court of India. He had represented the cause for 4 lakh primary school teachers before Honorable Supreme Court of India in the matter of equal pay for equal work. Looking into the expertise of Mr. Animesh in constitutional matters, he was engaged as a counsel by the state of Chhattisgarh in the matters relating to reservation policy promulgated by the Chhattisgarh state. It's an honor to have you here, sir. We welcome you. Sir, you're muted.
I'm sorry. Good evening to one and all present here. Honorable Mr. Justice A.K. Sikri, the former judge of Honorable Supreme Court of India, Madam Pinky Anand, former Additional Solicitor General and Senior Advocate, Mr. Ratan K. Singh, the renowned personality in the field of ADR, and the participants present here. Firstly, I would like to congratulate Team Nyaya Sastram for successfully organizing the competition. Being part of this competition, it would be my privilege to thank all of the dignitaries present here. We as a Fiducia Legal always committed to support such kind of initiative and always looks for the opportunity to part of it. When Abhishek came up with this proposal, we had gladly accepted this to support the competition. Now, so far as topic is concerned, everything is covered. Only few things I would like to add upon. With respect to the negotiation, My Lord Justice Sikri as well as Madam Pinky Anand has said to encourage negotiation more in our day-to-day procedure. I remember there is a procedure in MSME Act to have conciliation before institutional arbitration. So I think we should incorporate same in other field also. So now I think everyone is waiting for the result, and I'll do the work for which I have been called for to announce the result till semi-final round. So with the permission of My Lord Sikri and other dignitaries, may I announce the result till semi-final round?
Yeah, proceed.
Thank you, my Lord. So far as preliminary round, knockout and quarterfinals, there are 3 head under which I will announce the result. The first is best negotiation team. The second is best advocate. And the third is best client. So far as preliminary round is concerned, the best negotiation team is team of Symbiosis Laws. Best negotiation team is of Symbiosis Law School, Hyderabad and National Law University, Delhi. Symbiosis Law School, Hyderabad team comprises of Aparna R and Kalpatika M. And NLU Delhi is of Labdi Golencha and Ishan Agrawal. The best advocate for preliminary round is Aparna R, Symbiosis Law School, Hyderabad, and Labdi Golecha, National Law University, Delhi. And the best client is Kalpaltika M, Symbiosis Law School, Hyderabad, and Ishan Agarwal, National Law University, Delhi. So far as knockouts round is concerned, the best negotiation team was Ritvik Guha Mustafi and Tusharika Vij, School of Law, Christ, deemed to be University, Bangalore. The best advocate was Ritvik Guha Mustafi, School of Law, Christ, deemed to be University, Bangalore. And the best client was Tusharika Vij, School of Law, Christ, deemed to be University, Bangalore. And for the quarterfinals round, the best negotiation team was Labdi Golencha and Ishan Agarwal, National Law University, Delhi. The best advocate was K. Swati Reshmitha and Pival K. Peddi Reddy, Nalsar University of Law, Hyderabad. And the best client was Anand Sancheti, National Law School, Odisha, and Ishan Agarwal, National Law University, Delhi. So far as semi-final rounds are concerned, the best negotiation team was again Labdi Golecha and Ishan Agarwal, National Law University, Delhi. And the best advocate was Labdi Golecha, National Law University, Delhi. And the best client was Ishan Agarwal from same law school. So this is the result up to semi-finals.
Thank you, Animesh, sir.
Am I audible?
Yes, sir. Yes, sir. You're audible.
Thank you.
If the judges permit, then we shall proceed with the announcement of the results for the final round.
Please, we are not only permitting you, we are waiting for that because we have to go on.
Okay. So the final results for the final rounds have been prepared on the basis of cumulative scores of all the three judges. I request Honorable Justice Dr. A.K. Sikri sir to read out the name that is present on the screen.
Yeah, for finals, best advocate is Ladi Golecha, NLU Delhi. Congratulations.
Thank you so much, sir.
I now request Dr. Pinky Anand ma'am to read out the result for the best client for final round.
I was muted. Ishan Agarwal is the best client. I really think that he did a wonderful job and a very charming personality. Ishan, congratulations to you. May you do well in life.
I liked your name, Arjun. I am also Arjun.
I now request Mr. Ratan K. Singh sir to declare the name of the winners of this of the first Ratan K. Singh National Negotiation Competition 2020.
Winners are Labdi Golecha and Ishan Agarwal from NLU Delhi. Congratulations.
Thank you so much, sir.
Last but not the least, I would also request Deepak to present the name of the runner-up team as they gave them the toughest competition. I'd request Mr. Animesh Kumar Singh sir to read out the names of the runner-up team.
It's Navsirat Kaur and Aditi Verma from UPES.
Thank you so much, sir.
Congratulations.
Thank you, judges, and thank you, participants, for participating in the first Ratan K. Singh National Negotiation Competition. I now invite Deepak, event head of the first Ratan K. Singh National Negotiation Competition 2020, to present the event report. Briefly, Deepak.
Yeah, yes, I understand. I will just quickly go through the So, as told, Nyaya Shastram is a student-run body where, with the aid and advice of eminent lawyers and advisors throughout the country, especially Mr. Ratan K. Singh sir, who's the chairman of the advisory board and who has always supported us for our endeavors throughout. So the founding members of Nyaya Shastram is Mr. Abhishek Bhushan Singh, Aniket Datta, and me, that is Deepak Thakur. And the advisory board, I'll just briefly take the dignitaries and the participants. So our chairman of the advisory board is Mr. Ratan K. Singh, and Dr. Avinash Kumar is our chief editor, followed by other dignitaries and renowned lawyers practicing in Supreme Court, Delhi High Court, and various other courts. This event in particular was in association with Chambers of Ratan K. Singh, Fiducia Legal, and knowledge partner was Justice Right Foundation. Also support partner was Society of Construction Law India. So list of participants, colleges, we had participants from various law colleges throughout India, Campus Law Delhi, CNLU, RMNLU, Government Law College, NIMS Mumbai, Law College, Dehradun, Nalsar, NLU Bhopal, NLU Odisha, NLU Delhi, NLU Jodhpur, Christ, University Bangalore, Symbiosis Hyderabad, UPS Dehradun, Symbiosis Noida, and NUJS. So the preliminary round was on 30th October, followed by out of 34 teams which participated in the prelims, wherein 16 teams qualified for the knockouts, and the knockout round was on 31st, wherein in knockouts 16 teams participated, wherein 8 teams qualified for the quarterfinals. Then quarterfinals was on 31st October, that is Saturday, wherein 4 teams qualified for the semi-finals, that is NLU Delhi, Nalsar, UPS Dehradun, and NUJS. Then semi-finals was today itself in the afternoon, wherein 2 teams from the semi-finals qualified for the finals, that is NLU Delhi and UPS. These are the judges of the prelim rounds. Judges for the knockout rounds, judges for the quarterfinals, judges for the semi-finals, and judges for the final rounds. As we all are aware of, Honorable Justice Sikri, Dr. Pinky Anand ma'am, Mr. Ratan K. Singh sir, and the drafting of the problems were by Ms. Lippy Parashar. She's a student of Christ. And the others are practicing advocates. And this is the team of Nyaya Shastram. Thank you.
Thank you, Deepak, for presenting the event report. We shall now move on to the last segment of this session. I invite Mr. Abhishek Bhushan Singh, founder and managing director, Team Nyaya Shastram, to render the vote of thanks. Over to you, Abhishek.
Thank you, Aniket. I, Abhishek Bhushan Singh, founder Nyaya Shastram, take great pride and privilege to have been given the opportunity to propose the vote of thanks on behalf of the entire team of Nyaya Shastram. I would like to express our heartfelt gratitude towards all the guests who have been graced us with their presence and provided very valuable insights while addressing the gathering today. I am sure your words have definitely encouraged students to take up more ADR activities in the future. First and foremost, I express my sincere gratitude to the Honorable Justice A.K. Sikri sir for being a part of the valedictory ceremony of first Ratan K. Singh National Negotiation Competition 2020, despite his very demanding schedule. The participants have benefited immensely from the inputs provided by you, sir. We thank you for your gracing this event. I'm immensely grateful to Pinky Anand ma'am for being part of our event. I'm certain that participants have had a lot of lucrative and fruitful knowledge to gain from you. Your presence amidst this gathering today is deeply valued by us, ma'am. I am immensely grateful to Ratan K. Singh sir for his non-ending support for Nyaya Shastram. I believe participants have benefited immensely from the inputs provided by you, sir. We thank you for gracing this event with your presence. I thank Animesh sir for his constant support to Nyaya Shastram and believing in us. I would like to acknowledge our associated partner for the first Ratan K. Singh National Negotiation Competition, Chambers of Ratan K. Singh, and Fiducia Legal Advocates and Solicitors for rendering their support and having confidence in our team by allowing us to collaborate with them for this event. I would also like to thank Society of Construction Law India for being our support partner, Justice for Right Foundation for being our knowledge partner. As Henry Ford has once said, coming together is a beginning, keeping together is in progress, and working together is success. I would like to thank my co-founders, Deepak Thakur and Aniket Datta, who has been a constant support without whom this event would not have been conducted the way it was. On behalf of my co-founders and I, this event has been our long-lasting vision for the Nyaya Shastram, and we are humbled to see it into fruition. This vote of thanks would not be complete unless I thank the entire team of Nyaya Shastram. Thank you so much.
Thank you, Deepak. And with this, we come down to the ending of the valedictory ceremony of the first Ratan Kesing National Negotiation Competition 2020. Thank you all the judges, thank you all the participants, and thank you all the volunteers for taking out time and for being a part of the first Ratan Kesing National Negotiation Competition 2020. We are truly grateful to all the judges for taking out time. Thank you so much, sir and ma'am.